Hi, everyone. Welcome to another edition of Spilling the Tea on GovCon. I'm Teresa Moon, Director of Marketing for Parabolis. We are the preeminent partnership for government contractors, providing holistic support that includes a line of credit to fund your growth. The purpose of this podcast is to assist small businesses with success in the federal marketplace by introducing them to industry experts and resources that they may not otherwise know about. Today, my guest is my friend, Steve Koprince. For those of you new to the show or to government contracting, he is a widely known GovCon legal expert and one of my go-to sources for all things GovCon. We recently collaborated at an event on the subject we're discussing today, and I found the impact worthy of another conversation. Steve was also our very first guest. I always have to note that, and I'm forever grateful for your continued support. So welcome, Steve, and thank you for joining us, which I think this is your third time, maybe fourth time on the show. So thank you for being here.
I think so. Yeah. Thank you so much for having me again, Teresa. Always a pleasure, and obviously the enduring honor of being your first guest, and I appreciate that very much. And it was so good to see you last week in Washington, D.C. for that event, and look forward to continuing the conversation today.
Likewise. Thank you again. It was very impactful, and so I thought it definitely deserved another go around. And what I'd like to start off with, though, is for those that are new to the show, new to GovCon, if you could take some time to introduce yourself, give a little bit of background about your experience in government contracting, and then what you have going on professionally today.
Absolutely. So I am a former government contracting attorney. I spent somewhere between 16 and 17 years practicing government contracts law, 50, 60, 70, 80 hours a week. Represented over 1,000 clients. Most of them were small businesses, but also some mid-sized and larger businesses, including some of my small business clients who ended up growing to be mid-sized and large businesses, which is always wonderful to see. Spent a lot of time working on Mentor-Protege program issues. In fact, the program we're going to talk about today, the SBA's Mentor-Protege program, I've been working with that since its inception, at least for all small businesses to be able to take advantage of that program. I've done a lot of work on Mentor-Protege agreements and the joint venture agreements that often are kind of part and parcel of that Mentor-Protege relationship. These days, like I said, I'm no longer practicing law. I decided I was getting a little burned out and wanted to do other things, one of them being teaching and advocating for small businesses. So I do that now. I'm a teacher of government contracts topics with an organization called Govology, which provides online training primarily for contractors, but we're also moving more into providing training for government officials as well. And I'm excited about a class I have coming up next month that's targeted at government folks. I'm also on the board of directors of a tribally owned holding company of 8A and non-8A small businesses. It's a wonderful organization, former client of mine, just a great culture, great people, and I'm really proud to be part of that. I'm doing a fair bit of volunteer work. I'm on the board of directors of a nonprofit that provides wraparound services to folks in need in my community. And I'm in the trenches doing the volunteer work, 8 to 10 hours a week as well. And I'm a father and husband too. And I've got a lot going on. The kids are at the age where I'm shuttling them from one activity to another. And it's wonderful that I have the time now to be more part of their lives as well.
Understood. I'm right there with you. I refer to myself as Moober, otherwise known as Mom Uber, because that's what I do when I'm not on the road meeting with people like you and small business owners. So I'm with you on that. And it seems like this is not a retirement in any capacity, because you've got more on your plate than most people do.
Yeah, I'm not programmed to just sit around and watch TV all day, get too bored, and so it's really a shift for me. And I'm not gonna lie, if you counted my hours, and as an attorney, I used to actually count my hours. I'm sure I work less than I used to, but it is by no means that I'm just doing nothing and lazing around. It's a shift of priorities and activities.
Yeah, and anyone that knows you knows that that's true, because what we'll talk about a little today is the extensive writing that you do on multiple topics, and this one in particular. And so, you've written extensively about the SBA's Mentor-Protege and joint venture programs and the proposed changes that are freaking people out a little bit right now that are circulating around. You've done a great job, though, of breaking it down for lay people who don't understand the legal jargon that's put in there and all the things, the nuances to it that can confuse people and make them kind of run down a rabbit hole of things that aren't actually happening. So I'm glad that you're here to kind of explore that avenue, so you can really let people know what the proposals are actually all about and not set in regulations. And so we're going to get into that a little bit. And, a lot of this is impacting different socioeconomic groups. Specifically, hub zone businesses were referenced quite a lot in some of the writings that you've done recently. So I want to dive right in and grab your insight on some of this. You spoke a little bit about your experience with the Mentor-Protege program already. How about professionally? What was your experience with these programs and the clients that you were working with in the past?
Yeah, and so I've been working, as I said, with clients on this SBA Mentor-Protege program ever since the program went available to everybody, which is about 2016. And before that, I was working with 8A clients because the current SBA Mentor-Protege program really grew out of a successful program that had existed for many years prior that the SBA ran, but it was exclusively for 8A companies as proteges, and then typically large business mentors in that program. And so, yeah, I mean, ever since that program was available for 8As, and then after that for everybody, I had clients who would come to me for multiple things. And one was just to help them understand better what their opportunities were available. Most of the folks who came to me were on the protege side, but some on the mentor side as well. So I represented both, helped them walk through the process of applying for the Mentor-Protege program if that's what they decided they wanted to do. And so you don't need a lawyer to do that necessarily, but I think some of my clients felt that I could provide some good guidance and assistance to help them maximize the value of that Mentor-Protege agreement in terms of the business development assistance they were getting, and better understand the process so that they were poised to have that agreement approved the first time it went in, instead of going back and forth quite a bit with the SBA. And then, when we talk about SBA Mentor-Protege program, the next phrase out of people's mouths usually is joint venture. That's what people, and some people don't even understand, and we can talk about misconceptions in a bit, that those are two different things. The Mentor-Protege agreement is not a joint venture agreement, but the Mentor-Protege program does allow the mentor and protege to form this special type of joint venture in which the mentor's size is not considered. And so under the Mentor-Protege program, the mentor size simply doesn't count when that joint venture is going after small business set aside, 8A set aside, service disabled, veteran owned, hub zone, what have you, any contract for which size is an eligibility factor. And that's very appealing for both mentors and proteges alike. They feel it can make them more competitive. And so I have worked a lot on helping clients form those joint ventures and do it in a way that is compliant. And that is really, really, really important, because it's a powerful advantage. But the SBA imposes a bunch of mandatory requirements that have to go into your joint venture agreement in their regulations. If you miss even one of those, then there are about 16 of them, depending on how you break them down by subcomponents and such. But if you misfire on even one of them, miss it or get it wrong, say the wrong thing, and use the rule that was 3 years ago, but SBA has changed it now, any of that stuff, and someone protests your award as a joint venture, your agreement's invalid and it can't be fixed for that contract, and your contract goes away. So I always told my clients, look, do what you want on the upfront with the Mentor-Protege agreement. I think I can provide value to you upfront as an attorney to help you maximize the benefits of that agreement. But if and when you decide to do a joint venture agreement, please get an attorney, if not me, then somebody else in the field who knows what they're doing, because any mistake in that joint venture agreement could cost you a contract. We want to make sure we get that thing right. So I did a lot of time spend with clients walking through the joint venture agreement, drafting them, making sure those agreements were compliant, and of course with the compliance also worked well for that joint venture as a document that was going to govern its relationship, because it has to do two things. It has to comply with SBA rules, but it's also a set of rules for how that joint venture is going to be run for the life of its existence.
Right. And I've heard you reference on many occasions as well, is that, one is the difference in the agreements. And here's where the misconceptions come in, I think. And so it's a good segue into it. One is a relationship. The other is a marriage. And so being able to decipher between the two to make sure that you're on point is important to be protected. That marriage side of it, right? Those of us who have gone through the ultimate end to something like that know that if you don't tighten it up in the beginning, you end up suffering the consequences after the fact. And so, there's a lot of misconceptions that people have, just the pure difference between mentor, protege, and joint venture, and what that means to the relationship itself. But What are other misconceptions that small businesses should be aware of before entering into the relationship?
Yeah, so let me mention a few actually, just very quickly, but I think that are important for folks to know. So first things first, the mentor-protege agreement is not a joint venture agreement. I mean, they're two different things. The mentor-protege agreement is a business development agreement. It's an agreement by which the mentor agrees to provide targeted business development assistance to the protege with the blessing of the SBA. If the parties choose, and most do, but not all probably, you can then use that mentor-protege approval to separately form the joint venture and use that joint venture to pursue contracts. But just having a mentor-protege agreement, that itself is not a vehicle of any sort to pursue contract. You can't mentor-protege for a contract. What you can do is, take that mentor-protege agreement and not count the mentor's size when you're pursuing small business set-aside contracts or some socioeconomic subspecies with a separate joint venture that you would form. So two different things. Another common misconception is that you have to have a mentor-protege agreement to have a joint venture. And the answer to that is, as we lawyers or former lawyers like to say, it depends. It depends on your status. And so two small businesses can joint venture for a small business set-aside contract without a joint venture. An 8A small business can joint venture with a non-8A small business without a mentor-protege agreement. You don't need mentor-protege agreements unless the mentor is a large business and the contract that you're pursuing requires the prime contractor to be small. That's the only time you need it. And so if two companies want to go after an unrestricted contract, it's not set aside or sole source for small businesses, you don't need a mentor-protege agreement to do that. The mentor-protege agreement simply allows the joint venture that normally both parties in the joint venture have to be small businesses if you're going to pursue any contract for which size is an eligibility factor. The mentor-protege agreement simply takes the mentor size off the table. And so when you think about it that way, you say, well, if it doesn't matter if the mentor size is taken off the table, then you don't need the mentor-protege agreement. Again, two small businesses don't need a mentor-protege agreement to do a joint venture. It's a common misconception. You can get it. A small business is allowed to be a mentor, but you don't need it. Another misconception is that the protege essentially gets to use any certifications or statuses of the mentor. And the one I see this most commonly is with facility security clearances. They say, look, I'm an uncleared small business. My mentor has an FCL, facility security clearance. If I get a mentor-protege agreement, I can use my mentor's FCL. No. That is a huge national security nightmare. Can you imagine if the rule was simply, okay, everybody else has to go through this really tight process of being evaluated for a clearance, or you can just go around and do an end around by getting a mentor-protege agreement. It doesn't work like that. Now, the mentor can, as part of its assistance to the protege, sponsor the protege for an FCL by, say, giving the protege a small subcontract on a cleared contract that requires access to classified information. So there is a connection there, but the protege still has to separately go through that process. One final, I don't know if it's a misconception, but just one thing that I would tell proteges to keep in mind as well, or prospective proteges, because one thing I've often seen is a prospective protege hears about the benefits of this program. They're like, wow, that sounds great. I want to do it. And they're kind of looking around like, who wants to be my mentor? Who wants to be my mentor? Generally speaking, and there are small exceptions, but generally speaking, a protege is only entitled to 2 mentors in its lifetime, period. Okay. And so if you just pick the first company that comes along without any really evaluating whether that company is going to be a good mentor for you, whether they're going to have that life up to 6-year relationship potentially that's going to really benefit you, it could be missing the trees in the forest thing, right? I mean, you're jumping into this relationship, but you've already burned now one of your 2 lifetime relationships. And so I do say, yeah, I get it, proteges. You hear about the benefits of this program, you want to jump right in, but do your due diligence, because you likely, and there are now some minor exceptions, but you likely only have two companies that are going to be your mentors in the lifetime of your business. And so choose wisely. Choose those companies wisely.
I mean, you burn up one of your wishes, then you only got one left.
That's right. You got one left. It's like the genie coming out of the bottle. They only got 2 wishes this time.
Yeah, exactly. So what happens on the other side? Now, can a mentor have more than one protege at the same time? And then are they restricted as far as proteges over the lifetime of their business?
Yeah, that's a wonderful question. And both mentors and proteges were sometimes surprised when I gave them the answer to it, which is that SBA allows a mentor to have up to 3 concurrent proteges. with the caveat that the proteges can't be active competitors of one another. And so the mentor, when it's going in for that second and third approval, has to show like, hey, that protege A is in general construction and they work in Florida, and Florida, protege B is in especially trade construction, they work on the West Coast, or things like that, to show that they're unlikely to compete with each other. You never know what the next 6 years holds, of course, but and there's a restriction that says, hey, the mentor can't joint venture with two proteges for the same multiple award contract. So the mentor would have to pick. And the SBA doesn't want the mentor to have to pick. They want companies that aren't likely to compete for those contracts. But with those caveats, a mentor can have up to 3 concurrent. That means that some mentors might say, okay, you're my 8A protege, you're my hub zone protege, you're my SDVOSB, service disabled veteran owned small business protege, because that's a great way to get into VA, which prioritizes those companies. So some mentors don't know that. And so I've had proteges who didn't know that either, and they've had conversations with a company they like. It's a big potential mentor, and that company says, oh, sorry, we've already have a protege. I'm like, yeah, but they could have 2 or 3. And they're like, so ask them, do you have 3? And you don't even have to ask now. The SBA publishes a list of all the active mentor-protege agreements, so you can see if you're talking to a potential company or targeting a potential company as a protege or as a mentor, whether they already have an agreement and who with and when it expires. All that data is publicly available.
And how long is that relationship per mentor-protege?
So mentor-protege agreement can last typically up to 6 years. SBA recently changed the rule for proteges, saying, look, proteges, you can have 2 6-year mentor-protege agreements. Ordinarily, those will be with 2 different companies, but now they're to change the rule to say it could be 12 years essentially with the same company. But then you only have 1 lifetime mentor, and the mentor is going to have to agree in the second 6 years to do some stuff it didn't do in the first 6 years. Essentially, a brand new agreement with the same mentor. That is, I did forget to address one important aspect of your question. A mentor does not have any lifetime limit on proteges. It's 3 concurrent. But a mentor can continue being a mentor forever. And so there's no lifetime limit. The protege has a lifetime limit on being a protege, but the protege could then flip into the mentor role as it grows. And I've had some former clients who had good success with that as well.
Okay. Well, that's great information. In the conversation that we had in that event last week, this was the part that got a little squirrely. Even some of the government people that were represented there were a little off, because in typical government fashion, it changes all the time. And so there was like, wait, what is it then? And you were the only one that knew for sure.
Well, the SBA's been tweaking these rules for a lot, often, and clarifying, what they intended here and there when the rules aren't so clear, and then some of their new proposals do some of that stuff as well. But they're trying to be fair to everybody and say, now, look, why, 6 years with 2 mentors, but if the same mentor would be great for 12 years, then okay, then 1 12-year mentor, but no protege. The SBA's proposal now is to clarify what there has been their policy for years now, is that a single protege is going to have more than 12 years of being a protege. You can't be a protege for more than 12 years as SBA's.
Well, that's easy enough to remember.
That one we can remember.
They change it.
Until they change it, which will probably be next year or something.
Exactly. Yeah. Well, I mean, speaking of that too, and from your long legal background, what are some of the legal considerations that small businesses may often overlook when entering into these agreements, with regard to intellectual property and whether or not their relationship is using them for the betterment of the bigger company? Because I know we see that often as well. Of when I will refer a business to legal advice, it's usually for the purpose of making sure that small business is going to be protected and not have their intellectual property potentially stolen from them, or being utilized to an extent that is more beneficial to the mentor, as opposed to being a joint benefit to both companies.
Right. And let's be clear here. I mean, the rule is not that the mentor doesn't get to benefit from this relationship. SBA does understand that the joint venture is supposed to be, as you said, a mutual benefit. And so there's, I've heard some chatter every now and then, like, oh, it's bad for the mentor to benefit. No. The mentor wouldn't be doing this in the first place if they didn't get a benefit from it. And that is access as a joint venture partner to contracts they don't qualify for. I mean, that's typically what they want through that joint venture arrangement. And that's totally fine. SBA set it up that way to provide an incentive for companies to be mentors. So that's, but there are certainly, this is in the picking wisely categories, certainly things that the protege has to watch out for. The first thing that I typically told a new client who was coming in and they were trying to negotiate a mentor-protege agreement is that, don't skip directly to the joint venture. Yes, that is what the mentor likely wants. If they're a large business, that's their primary motivation for doing this. Maybe their only motivation for doing it. And for the protege, it's often a powerful motivation too, because the protege sees potential to be more competitive if they bring at that prime contract level this larger, more experienced business. However, the Mentor-Protege agreement, the whole purpose of it on SBA's eyes from the protege perspective is that it's a business development agreement, that it's supposed to provide the mentor is supposed to provide targeted business development assistance that essentially matches the protege's needs in its business plan, or as it's listed out those business needs. So those might be things like sponsoring the protege for a security clearance. It might be things like, if it's a construction firm, guaranteeing bonds at a higher level so that protege can access bonds at a higher level from sureties that wouldn't provide at that bonding with its current financial situation. It might be things like training the protege on how to write proposals, helping you get certifications like ISO certification, all sorts of different things, but it's what does this individual protege need? And that's what SBA is looking for in the agreement, but it's also what the protege needs to insist on when they're negotiating these agreements with the mentor.
Right.
If you send an agreement to the SBA that literally says the only assistance is joint venturing, SBA will probably reject that, so it's not a good idea from that perspective, but you're also really undervaluing as a protege what you should get in terms of targeted business development assistance that meets your needs. With respect to then negotiating other agreements, the mentor-protege agreement generally follows a pretty closely a template that SBA has provided on its website. In fact, I've seen some analysts at SBA, or I've heard of some analysts at SBA recently that are really sort of insisting on close adherence to that template when that template was really supposed to be a sample that was optional. But regardless, as it's a good sample, it has all the legalese SBA wants to see. So varying from it is probably not a good idea. You still have to do the work of filling in the blanks of all the assistance and that sort of stuff. But when it comes time to negotiate things like joint venture agreements, subcontracts, teaming agreements, that's when small businesses or non-disclosure agreements, when you talk about intellectual property, that's when small businesses need to be careful. And if possible, if they have the resources, have legal counsel that represents them, not that represents the mentor or the joint venture, because that's a joint entity, represents them. Look at those agreements and make sure they're fair, because what I've seen from some, and this is just not to tar all large businesses, I've represented some, I know some who are wonderful and don't do this stuff, but either the large businesses or their attorneys sometimes on their behalf will impose really one-sided type agreements. So I've seen, for example, here that, sign this non-disclosure agreement, and the non-disclosure agreement says, protege will not disclose any of the mentor's information ever, and if it does, they owe their firstborn children to the mentor, and yet the mentor can disclose any of the protege's information. This one-sided protection disclosure agreement, that's a huge red flag. Like, why? The mentor not agree to equal protection of data for the protege? So things like that the protege has to understand, and the big picture is, because I don't want to get into the nitty-gritty of negotiating these agreements. The big picture is, just because it comes from a mentor or a large business, doesn't mean that it's actually
Okay.
when I And so when I was practicing law and advising clients who were small businesses, who were proteges, or even non-protege small businesses about negotiating agreements with mentors or with large businesses, I would give them two big pieces of advice, big picture wise. First would be not to assume that just because the draft agreement, and usually it's the mentor, the large business, says here's the draft, that just because it comes from a large business that it is 100% compliant with the rules. You might think so. You might say, hey, these guys, I know who they are. I know they know what they're doing. It's got to be compliant with the rules. But I can't tell you how many times I had to go back to a large business and say, hey, this piece of the agreement actually conflicts with Rule X, with FAR Part Y, et cetera, et cetera. So I would say don't assume that that's the case. And certainly when you're talking about a joint venture agreement, remember how we talked about earlier, how these joint venture agreements, you get even one little piece wrong and the joint venture agreement is invalid. Don't assume that the mentor says, here's our template, we used it on this other contract.
Right.
Okay, was that contract protested? Did SBA review the agreement, or is it just one that you use? Because I have seen a lot of templates provided by mentors that are not correct, and had to fix them, politely. Hey, mentor, sorry, you got this wrong. And that's not, again, that it might be perfect, but don't assume that it is. A second would be, don't assume that the agreement is fair. Don't assume the agreement is written to be fair to you as the protege. Even if you and the mentor get along personally really, really well, if they're a large business, they're used to kind of being the driver in negotiations. They're used to doing things their way, and they may have aggressive attorneys who are used to writing documents that are more aggressive than the type of relationship you may have with their C-suite type staff or their small business folks. And so, for example, I've seen agreements non-disclosure agreements in which the mentor says, you will protect all of our information and we'll protect none of yours. We have the right to, post your confidential information on the internet if we want. And the agreement doesn't say that, but that's what it means ultimately. Is that anything we give you, you can do whatever the heck you want with it. And so I would, if at all possible, as a small business negotiating these agreements, have legal counsel. And this is not an ad for me. Like I said, I'm retired from that work. I have no dog in this fight, other than as a small business advocate. Have a lawyer who knows this stuff, who's a government contracts attorney, review these documents from the perspective of compliance and from the perspective of, is this a fair agreement for both parties? Keeping in mind that, you as the protege are entitled to something that's fair, that's fair to you, and that doesn't, protect their information and not yours. There's no reason to sign an agreement like that.
Right. And I mean, we hear about it happening. That's why, if they need a resource within the legal realm, I would be happy to, give some recommendations, because it is the worst place to be when you are thinking that you're going to benefit from something and then come to find out that you didn't read the fine print, whatever it is, or you didn't understand it. It's always important to have resources around you that can help you with the things that you're not completely aware of. And it happens. And so, to close up on this subject, I think some of the things from an article that you've published recently on your newsletter, talking about the proposed changes that have just been drawn out recently, and regarding the affiliation exceptions for multiple award contracts and the duration of the joint ventures. So, this is all a proposal of things, right? We're not supposed to take it as gospel yet, but what are your thoughts on some of those potential changes, and how do you believe that this could or may not create a more equitable environment for the small businesses themselves?
Yeah, it's a good question, and there's a lot of confusion here, and I don't want to go too much into the weeds here. But recently, SBA has done two things. In July, they introduced what they called a tribal consultation notice, and the tribal consultation notice is literally that. It says SBA does this from time to time. One of their constituencies are Indian tribes, and they say, we're going to meet with the tribes in various, we're interested in like 5 or 6 cities around the country. Here's the times of the meetings. Here's when those are going to take place, and here are the topics we're interested in discussing. And buried in that notice to tribes was this notification that one of the things we'd like to talk about essentially is whether mentor-protege joint ventures have become too powerful. They didn't say it quite that way, but they said, our mentor-protege joint ventures winning a quote-unquote inordinate amount of work on multiple award contracts, some of these big GWACs and other vehicles that account for maybe a quarter of federal spending in the last fiscal year, because there's a perception out there in the community that this is the case, that regular small businesses who don't have mentors are being disadvantaged now because they have to compete, go head to head with these mentor-protege joint ventures who count as small, even if the mentor is a $10 billion company. And is that, what do you think about this, tribes? Right. What SBA said in that tribal consultation notice was, we are considering, but not proposing, we're considering two things. One would be to simply ban mentor-protege joint ventures from competing for multiple award contracts, which would be a major change. Yeah. The second would be to ban mentor-protege joint ventures from competing for any contract that exceeds a 5-year duration, which there are some single award contracts that fall into that category as well, and some multiple award contracts that don't fall into that category. So that would be another way of doing that. But SBA, to be clear, did not propose to do this stuff. They said, hey, tribes, we're thinking about this inside. We actually have two different ideas. What do you think? Should we do any of this stuff? None of it? Whatever. That, of course, got the community very intrigued. I would think it was a poor, from a communications perspective, it was a poor way of SBA handling it, because it was kind of slipped into this notice. It looked like SBA was only interested in the tribe's perspective on this stuff, where of course it affects, and that wasn't really SBA's intent. I think it was just a poor decision to put this in this tribal consultation notice without ever introducing it to the larger community. And so SBA actually in September clarified, they issued in the Federal Register a formal clarification. They must have heard from a lot of folks saying, look, the things that we put in that tribal consultation notice, I call them, the SBA has not used this word, I call them trial balloons. They're essentially ideas that we floated out there. But to be clear, this is SBA now saying this, to be clear, we have not proposed to change the rules to do this. We just really want to take the temperature of the community regarding this. This tribal consultation rule was followed about a month later by an actual formal proposed rule in the Federal Register. And if you're the sort of person who is a regulatory nerd like I am and understands how the Administrative Procedure Act works and how regulations are written, that's the step they take before something actually becomes law. They put a notice in the Federal Register and say, here are the specific changes we would like to make. Okay, everybody comment on those specific changes. The things that were in the tribal consultation notice regarding the duration, that was not in this proposed rule. SBA did have some items in this proposed rule regarding Mentor-Protege joint ventures, but not those things. And so those things are not actually pending as proposed rule changes right now. But they are obviously things SBA is thinking about and trying to take the temperature of the community. People have asked for what's my opinion on these. They're obviously big changes if SBA were to do them, which, again, to be clear, they are not proposing to do them. They are taking the temperature of the community on these potential changes, and nothing more at this time. What do I think about it? I would say I can't, as a small business advocate, really give a position until I know the numbers, because SBA in its tribal consultation notice said there's a perception that the Mentor-Protege joint ventures are winning an inordinate amount of these contracts. Well, okay, but a perception to me is not a good basis to change the rules. I want to see what the numbers are. If it is true that Mentor-Protege joint ventures are just winning so many more contracts than their numbers would support under these multiple award vehicles, well, maybe that's something we have to address, keeping in mind that SBA represents multiple constituencies. Some of them are proteges, some of them are not. And so SBA needs to find a common ground.
But I mean, even your last article pulled that out from numbers from 2022 and 2023 that didn't support this perception, which you also said that was their like Bill Clinton moment of what's the true meaning of is, you know what I mean? It's like perceived. Whose perception are they representing in that? If they're saying that it's not our perception, it's just what other people are saying.
It's what other people, and so that's a thin basis to me for a regulation. And now they haven't proposed to write one, but if they were going to propose to write a rule, I think you'd have to show, okay, here are the big contract vehicles, here's the numbers of Mentor-Protege joint ventures, here's the dollars they won versus, and then we can make a decision as a broader community and say, okay, we get it. There are plenty of small businesses out there who aren't proteges, who don't have those relationships. The world needs to be fair to them too. But when we're talking about such a major change, we're talking about like 25% of federal contracting dollars. Before we do that, it can't just be a perception. We got to get our arms around what the facts are here and whether these things have become too powerful. And I don't know whether but my article did also point out, because you mentioned earlier this one other change that SBA had buried in this tribal consultation notice was specific to hub zones.
Right.
And they said hub zones, we're concerned that hub zone joint ventures, Mentor-Protege joint ventures, get this 10% price evaluation preference. There's a special hub zone rule that says that when a hub zone business competes against a large business, the hub zone gets basically the agency has to pretend that the large business's price is 10% higher than it is. This means it only works on unrestricted contracts. So this doesn't even have anything to do with small business set-aside contracts. And so SBA says, well, we're concerned that hub zone joint ventures who get that 10% price preference, it's not really fair because there's a large business that's already part of that JV and they're and they're competing against other larges. So, but I don't even know why SBA would be concerned about that. I mentioned in my article that HubZone, the government has not met its HubZone goals for years in a row. It's only a 3% goal. That HubZones comprise the lowest number of proteges, only 200 some out of all the proteges that are under the program. I mean, HubZone, and that under SBA's own database is called the SBA Data Hub, where they post, you can get a breakdown of awards in the previous fiscal year by socioeconomic category. There's a very small number of awards that are associated with the category of HubZone price preference, where that was. And so it seems to me like, based on just on that data, I'm like, why would we do something that would make it harder for HubZones to win work? And in this case, SBA is not even proposing a solution that would benefit other small businesses. The only beneficiary of this proposal would be large businesses, because that's who the price preference operates against. A small business that's competing on an unrestricted contract, the HubZone price preference does not apply to the small business's price.
Right. Well, we're going to keep tracking this, because obviously more is going to be coming down, and you do a great job, like I said, of breaking it down, because your head could spin with just the understanding of the two differentiations between Mentor-Protege and joint venture alone, and all that it entails. And so I definitely appreciate you always having a knack for being able to make it palatable for those of us who do not have a legal background. And so we'll definitely track this and have you back on to give any updates as they come through. I imagine that they're going to be feet to the fire and have to tell us something eventually. So
I would think so. And it may be this thing just dies, and we'll see what happens with the change of administration coming up too. That can be different leadership at SBA with different priorities. So there's a lot on the horizon. I think one of my fellow panelists on the panel that we were both with last week said to folks in the audience, look, if you're thinking about doing this, don't worry about what's in the future right now. Keep an eye on it, but if it's right for you, then go ahead and do it. And I would agree with that.
And that's great advice. And so with that, I want to thank you for being here and always sharing such great information. And we'll definitely have you back on very soon to talk about all the other things that you know a lot about too.
Well, thank you. Always a pleasure to be on with you. The time flies when we're chatting. So it was great to see you last week, and good to be able to follow up today.
Likewise. Thank you so much. And thank you all for joining us. As always, we pride ourselves on sharing the most insightful and exciting people and information to help you better navigate your GovCon journey. If you like what you heard today, you can see all of our past podcasts, which are archived on our YouTube channel by the same name. Stay tuned for all of our future guests in the coming months as we help you grow to great heights in the year ahead. I'm Teresa Moon, and this is Spilling the Tea on GovCon. Have a great day, my friends.